Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number JV150178. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and the client that you represent. Each side will have 20 minutes for argument, and Ms. Whitehair, as the appellant, you're responsible for watching the clock on the podium and reserving any time for rebuttal that you might desire. We have reviewed the briefs and conferenced the case prior to the argument. So with those preliminaries out of the way, Ms. Whitehair, you may proceed.
May it please the court? My name is Sunshine Whitehair, and I represent the Gila River Indian community. I would like to reserve 5 minutes for rebuttal. As a tribal member, I recognize there's no resource that is more vital to the continued existence of the Gila River Indian community than our children. Congress has recognized the important connection between Indian tribes and their children when it passed the Indian Child Welfare Act. One of the critical requirements in the Indian Child Welfare Act is the placement preferences. The United States Supreme Court has called the ICWA placement preferences the most substantive requirement imposed on state courts. And as a tribal member myself, I understand and appreciate this the most. Under ICWA, Indian children must be placed within the ICWA placement preferences unless the party establishes by good cause to deviate.
Now, what would the standard of the burden of proof for good cause be?
Your Honor, we would request that the burden of proof be clear and convincing.
Let me follow up on that, because I'm a bit curious as to why you didn't spend more time talking about that issue in the brief. It seems to me that's a pivotal issue and it's kind of a threshold issue. Is that something we need to decide in this case?
Your Honor, we would request that that be decided today.
And can you give us your assessment of what the state of the law is on that question, setting aside the pending regulations, which I might want to come back to in a minute, but it seems that the majority of state courts that have addressed the burden of proof issue under Section 1915 have, with one exception, gone with the clear and convincing standard.
As noted in the reply, the court was confronted with a similar issue, and I'm not sure if you're referring to this, but it's in Yvonne L. v. Arizona, DCS. And in that case, it was asked to determine the court was asked to determine a standard of proof for active efforts under ICWA. Even though this issue was not raised in the lower courts, the court there chose to decide that issue given the fundamental nature of the mother's interest in the custody of her children. The community does ask that the court consider the standard of proof for good cause determination, that given that the parents also have rights pursuant to the family relationships with their children.
And I guess you're right about the Yvonne case. That was an instance where we did not apply the doctrine of waiver and we considered the standard of proof issue on the merits, which is the question that we're faced with here. But my question was really about how other state courts have resolved the substantive question of which standard of proof applies to the placement preferences.
Your Honor, I would respond in that in other states, and it just depends on the jurisdiction, clear and convincing evidence has predominantly been the decision rendered being that it was the spirit and intent of ICWA. ICWA, most recently with the 2015 guidelines, although fairly new, provided direction and a framework for not only the courts to abide by, but also for the departments to abide by.
And as I understand, the guidelines have incorporated the clear and convincing standard, but as we know, the guidelines are not mandatory, they're guidance for state courts. But isn't there a proposed regulation pending that would codify the clear and convincing standard if adopted?
That's my understanding.
Do you know what the status is of that regulation?
I do not, but I do know that that is something that's been in the works, and the hope is that soon that it would be codified.
if we, hypothetically speaking, took on the standard of proof issue and determined that clear and convincing standard applies here, what should we do? Should we remand? What's the next step if that were the proper standard that the court should apply? Because we don't know what standard the juvenile court applied here, do we?
We do not, and we would ask that be taken into consideration, and because there was not a standard applied, that's why we're requesting that this go back to the lower court.
And if it did, should we, what if anything should we direct the lower court to do, since the evidentiary hearing was already resolved? Just consider all of the facts in light of the heightened standard, or something else?
That is correct, and the reason being is because we are making the argument that there was not reasonable evidence to make the determination by the lower court that that the placement preferences was abided by in the first place.
Well, so you, if I understand your response, it's, you should remand it, ask the juvenile court to apply the heightened standard, and then we'll see what happens from there.
That is correct. The community is requesting that the court reverse the juvenile court's under advisement ruling because the juvenile court abused its discretion when it relied on ordinary bonding.
Well, let me ask you about that, because admittedly, the court does talk about several of its bullet points relate to bonding, but that's not all it talked about. One of the interesting and potentially very significant factors here, as I understand the record, is that there's only one sibling subject to ICWA. The other three girls are not. And wasn't the commissioner also focusing on the fact that DB's foster placement has the younger daughter in their care and also is certified to adopt and is interested in adopting the other two children so that DB would have her three sisters with her?
Right, and Your Honor, I would ask that you consider that at the time of the good cause finding, the other siblings were not in the care of the fosters.
The youngest one was.
That is correct. The youngest one was, but at that time, the thought was that she was an Indian child, and the
Was not? Or,
was, and that's one of our concerns, was that because she was at that time thought to be an Indian child, then why wasn't there the placement with the aunt, the biological paternal aunt, as an ICWA compliant placement?
but the state of the record currently does not establish her as an Indian child because the father has denied her paternity and has refused to submit to paternity testing. So she doesn't qualify under ICWA as an Indian child at this point, does she, based on the record?
At this point, no, but at the time of the good cause hearing, it was the determination was they thought that she was an Indian child. Additionally, further, the court erred when it found that the state had made active efforts to locate the compliant placement and admittedly did nothing to locate family or tribal placements or follow up with one that was located by the community. There was no cause to deviate from the ICWA compliant placement preferences for several reasons. First, there was a failure to even look for family placements for Deborah. ICWA is a federal law that must be followed regardless of whether the tribe intervenes. Here, the state failed to conduct a diligent search for family members. What's more, the community located a family member placement and the state failed to conduct any meaningful follow-up with her. The state's failure to look for a placement or follow up with the aunt caused Deborah to stay with her placement for some time. And it was the lack of the ongoing search by the department that led to the length of stay that Deborah was with her foster family. Second, the court cannot rely on ordinary bonding to establish the compelling reason to deviate from the ICWA placement preferences.
Let me stop you there, because I would agree with you that they can't rely solely on what you call ordinary bonding, but we know from this court's previous decisions that we don't buy into the notion that only the 4 factors that the guidelines identify can be applied and that bonding can be considered as a factor. So unless we were to overrule our prior precedent, bonding can be considered in our state courts, can it?
It can, but it should, again, just be a sole factor, one of many factors for consideration. And speaking of the bonding, the juvenile court's decision to deviate from the ICWA placement preferences was not supported by reasonable evidence that Deborah B. would suffer any emotional damage. And the part of the bonding assessment that the court considered was Dr. Silberman's evaluation. And we argue that this case was biased and one-sided. Dr. Silberman only met with the foster family once for a couple of hours, and his testimony did not show that Deborah B. would suffer any emotional harm other than ordinary disruption.
Well, is a child being removed from a home that she's been in for 2 years and is the only family she's ever known, isn't it kind of a given that the child would suffer some emotional distress?
That is correct.
And aren't there, so for the court to consider, I don't think Dr. Silberman indicated that he thought that there would be some emotional distress on DB, and just because you don't agree with it doesn't make it a fact in the case, though, does it?
It does not, and that's something that we are contesting his evaluation. Additionally, that unfortunately it is a reality that children face when they are in the system. They do have to go from place sometimes to place, unfortunately, but the community offered or could offer a transition plan to mitigate any harm that occur. Additionally, when that harm, and if it does occur, it has to be extraordinary. Otherwise, the good cause exception would render the rule meaningless.
But if in fact the juvenile court used the wrong standard, then the court has to ultimately resolve that. And if it does under the proper standard, whatever the court's ruling, that may well be the next appeal, but we don't evaluate evidence here.
That is my understanding, Your Honor, that we're not asking that you reevaluate the evidence other than holding the lower court to the standard that applies. Again, under the BIA guidelines, the extraordinary physical and emotional needs of the child does not include ordinary bonding or attachment that may have occurred as a result of the placement or the fact that the child has, for an extended amount of time, been in another placement that does not comply with the Act. The good cause determination does not include an independent consideration, and in light of the purposes of the Act, this good cause finding should not have been applied and should not have been determinative as a good cause reason to deviate from the placement preferences. Finally, the court cannot rely on the foster parent's willingness to potentially expose Deborah to her culture at some point in the future. This is contrary to the word and spirit of ICWA. The juvenile court's decision to deviate from the ICWA placement preferences was not supported by reasonable evidence that Deborah would suffer any emotional damage, and that the finding, again, was based on Dr. Silberman's evaluation. In any change of a parent-child-like relationship, whether the initial moval from the home, as you mentioned, and then back from the placement to the family placement to the relative placement could cause some emotional disruption. However, this does not defeat the strong placement preferences within ICWA and the congressional declaration that the placement of the Indian child with their families is in the child's best interest. If we go back to Dr. Silberman's evaluation and whether or not it was reliable, the concern from the community is that there was no academic credentials or licenses that were provided, and he was not found to be a qualified expert witness. His evaluation was for the purposes of to assess the placement's parenting skills There was no interview with the mother, the tribe's case manager, or the community member prospective placement. The community's expert witness, however, directly contradicted each of Dr. Silberman's claims.
Aren't we getting to the point Judge Portley made earlier, though, is it sounds like you're asking us to reweigh the evidence and to place more emphasis on Mr. Donahue than on Dr. Silberman, which really isn't the role of the appellate court.
I agree with that, Your Honor, but the juvenile court's decision to deviate from the ICWA placement preferences was not supported by the reasonable evidence that Deborah B. would suffer an emotional damage. And the reason why we're stating that is because we feel that it was abused of the lower court's discretion. And the fact that the DCS failed to establish that the unavailability of a family placement is good cause to deviate from the ICWA preferences, good cause can be established only after showing the unavailability of a suitable family member, after a diligent search has been made. This was the intent of ICWA. In fact, there was an available family placement. She was Frances, who was the paternal aunt, and the state never looked for any other family member, much less conducted a diligent search.
You
What?
said you wanted to save 5 minutes, just so you know
Right.
you're under 5 minutes at this point, so
Thank
it's
you.
up to you whether you want to.
I'll just say one last thing and then I'll.
Okay.
So again, the possible future connection is not a good cause factor. The foster parent's willingness to expose a child to her culture is not supported by the evidence and just not a good cause and should not have been considered by the court. There was no evidence that the foster parents were currently exposing Deborah to her culture. Mere exposure is not a substitute for a lifetime of growing up surrounded by your culture and your family. The community greatly appreciates the current foster placement's commitment. However, they cannot teach Deborah how to be an Indian woman. Becoming an Indian woman, knowing your culture, and learning the O'odham language cannot be learned by reading a book or going to a website or visiting a fair. A promise to expose Deborah at some later date is not sufficient to establish good cause. Thank you.
Thank you.
May it please the court. My name is Joanne Falgett, and I'm representing the Department of Child Safety in this matter. I apologize in advance. I had some oral surgery done on Monday, and I'm still a little sore, so if I'm not enunciating very clearly, please just call that to my attention, and I'll try harder. It seems that the court's pressing concern this morning is about the standard of review, and I would first point out that this issue was not raised or discussed below, and arguably, as mentioned, was waived.
Well, we both want to jump in there. You know, I always think it's a dicey proposition for counsel to rely on waiver and not address it on the merits, because waiver is in the discretion of the appellate courts. And if you look at our decisions in juvenile cases and in family court cases for that matter, we rarely apply the doctrine of waiver where the best interests of children are at stake. So I know you said that in your answering brief, but I think you shouldn't assume that we're going to rely on waiver. And as Ms. Whitehair pointed out, in the Yvonne case, we did the exact same thing under an ICWA issue. So what is your review of other cases reflect? It seems to me the clear majority view is clear and convincing evidence of other state courts.
Certainly many other state courts have held that. However, if you look at the Navajo Nation case, that's 230 Arizona 339 was cited in, I believe, both briefs. It uses a lot of language that indicates that, in fact, the standard might be the preponderance that was mentioned as well.
I was on that panel and recall the case and reread it recently, and I respectfully disagree with that. First of all, that issue, and I went back and looked at that to see why we didn't address the issue in that case, and it wasn't raised by either side. So I think you're really trying to stretch the tea leaves by trying to read into that any decision on the merits of the standard of proof.
I agree there was no decision on the merits per se. It was not addressed in that case. I agree with that. I'm not trying to say that it was. But some of the language that was used certainly indicated that the court wasn't concerned about whether it was a preponderance of the evidence standard or clear and convincing, and certainly indicated that potentially had the court applied a preponderance of the evidence standard, that might have been okay. They say things like, for example, in paragraph 21, the court should start with the presumption that ICWA preferences are in the child's best interest and then balance that presumption against other relevant factors to determine whether placement outside ICWA preferences is in the child's best interest. And again, at paragraph 33, it says those factors have to be weighed by the juvenile court based on the unique circumstances of each case, and we will not reverse such findings unless they are unsupported by evidence. Now, I recognize that that reasonable evidence / unsupported by evidence standard can be applied regardless whether it's clear and convincing or preponderance of the evidence. This court does not typically reweigh evidence, just finds whether there was substantial evidence or reasonable evidence to support what the juvenile court did. But certainly that kind of language doesn't indicate any heightened standard was needed. Typically when the court talks about, for example, active efforts, they go ahead and mention the fact that a heightened standard is required and that the burden of proof is therefore somewhat stiffer, and that the evidence might be required to be a little bit more substantial than it would be under a lesser standard.
Well, let's say we don't think Navajo Nation addresses the issue at all. My review of state courts across the country is that with one exception, Oregon, in a footnote, everyone now applies the clear and convincing standard, including Alaska, who has overruled their prior precedent of preponderance and now clearly says clear and convincing. And if the intent of ICWA, which is one of its intents, is to be a nationwide uniformity, why would we not adopt, in this case, the clear and convincing standard?
I can see a valid point there as well. I would request that if the court is going to go forward and address this, that perhaps the court might order supplemental briefing and additional consideration. The other thing that I would suggest is that the trial court is presumed to know and to correctly apply the law. So to the extent that the majority of courts in other states have held that clear and convincing was the standard, perhaps it would be appropriate to assume that the trial court applied that correct standard in this case and made its findings based on that standard.
Well, we also know that most of the findings of fact and conclusions of law have, since our Supreme Court articulated, found that the reason for the termination was by clear and convincing, but the best interests were by preponderance. And it's been, at least since Kent came out, pretty clear in findings and conclusions, but yet here the judicial officer didn't do that. So how can we presume that she did in fact utilize the heightened standard?
Well, two things in response to that. First of all, that what you just said about the best interests typically being decided on a preponderance standard was another argument I was going to make in favor of saying this should be a preponderance standard. It's essentially a best interest argument.
But because ICWA's involved, ICWA boost in the federal statute, we know boost everything up. There was even a belief that you couldn't have severance unless you had it by beyond the best interest. But we've gone back from there, but at least with respect to clear and convincing.
Certainly, although this court has also held that the best interest finding does not have to comply with that heightened ICWA standard of the clear and convincing, that is just under the state law standard of preponderance of the evidence. So, but as I was starting to say, I don't think it much matters. I think that the trial court, again, could be presumed to have properly applied whatever correct standard is determined to apply. And I think that, or I know that the evidence in this case was certainly sufficient to meet whatever standard applied. The factors that the court considered were the same factors that were considered in the Navajo Nation case. The facts of the case were nearly identical to the Navajo Nation case, and in fact, if anything, there were additional factors stated in this case that would weigh in favor of a finding that the placement was appropriate.
But is that the role of the appellate court? Let's say we think clear and convincing evidence should have applied. Like we were saying to Ms. White here, we don't reweigh the evidence on appeal. So we don't say, oh, Mr. Donahue was stronger than Dr. Silberman, so the court erred. Similarly, it's really not our role, is it, to say, well, under a clear and convincing evidence, this would have weighed heavily, because there's quite a difference in those two standards of proof. So wouldn't a remand be required?
Again, I don't think it's required. I think whatever the standard was that was applied in the Navajo Nation case could be, those factors are applicable here. The evidence here is nearly identical to what was found there, and the court there held that it was sufficient evidence. So whatever the standard was, the evidence in this case is clearly sufficient to meet that Navajo Nation finding of.
What if the Navajo Nation, what if both the trial court and this court, myself included on that panel, we all thought it was preponderance? And so does that really get us anywhere if we're now saying, no, it's clear and convincing? I mean, I agree the facts are similar, and I also agree that it's possible a court on remand would say, even with a heightened standard, these same factors I have articulated support clear and convincing. But I'm just questioning philosophically, normally appellate courts don't sit there and weigh the evidence and say, well, this different standards, same result.
Right, and if the court had clearly said that it had applied the preponderance standard and this court clearly felt that clear and convincing applied, then yes, a remand might be appropriate to ask the juvenile court to articulate which standard it had applied, and if it had applied the wrong standard, to then, reconsider the evidence in light of the correct standard. If it had applied the correct standard to begin with, nothing further would need to be done. It could simply say that, that I did this under the clear and convincing standard. So assuming the court decides that that is the correct standard. So I think that is a threshold issue that the court may want to consider, and again, would request an opportunity to do supplemental briefing on the issue before the court takes that leap. But if the court is not inclined to do that, then and if the court does decide that the heightened standard applies, then certainly it would not require a complete reversal, but merely a remand to ask the trial court what standard it applied.
And then what should the trial court do? Should the trial court make its findings based on the record it has before it? Or
if the trial court already had applied the clear and convincing standard, then I think it could simply state, regardless of the fact that I failed to include this in my minute entry, I was in fact applying the clear and convincing standard, and therefore my findings remain. If, on the other hand, the court did apply a lesser standard and that this court felt was inappropriate, then it would be appropriate, again, for the court to consider those same findings and that evidence in light of the new standard and whether that was an appropriate order or not. I don't think that it would need to take new testimony. The court was already there, heard the testimony, has the transcripts and the documents before it. But certainly if the court decides that the standard is one thing and the trial court admits to applying a different standard, then it would be appropriate for the trial court to do that reweighing of the evidence.
And what about the regulations? Do you have any information on where those stand?
I have been out of work most of this week, so I didn't check this week, but I did check on Friday, and as of Friday, the regulations had not been codified. I would point out, though, that let me find my notes here.
Is the comment period has expired, correct?
Yes, and they're just waiting to, I guess, decide what they're going to do.
And if those are codified, then it kind of renders moot our discussion here, because those will impose a clear and convincing standard for the placement preferences, correct?
Possibly, although there have been some changes to the guidelines compared with the proposed regulations, and could still be more to come. So, it's impossible to say at this point what exactly the regulations would look like.
Regulations in their current form disagree with the guidelines say something like you're not supposed to consider best interest again, and the regulations took that out.
Yes, they did. So if in fact those do end up codified, certainly the best interest consideration would be wide open. Already it's open. Again, the Navajo Nation case and pretty much every case that has considered it has held that regardless of the guidelines, they're just guidelines, and the courts consider may consider other factors other than those just listed in the guidelines in determining the best interests of the child. And certainly that Navajo Nation case went through a variety of factors that are relevant to that determination.
What's your strongest argument for the for upholding the trial court's order in regards to using a a heightened standard? What's your
Using the heightened standard?
heightened standard?
Well, again, the trial court is presumed to know the law and to properly apply it, so I think that this court could apply that typical appellate court presumption that is made. And then looking at the evidence, the question is there reasonable evidence to support a finding
That's what
based
you're
on that?
asking. Is it, what's the evidence that you
Oh,
think
what
is
is
the
the evidence?
strongest?
I'll be happy to go through that. Again, the court considered the exact same factors that were considered in the Navajo Nation case. For example, the child here, DB, had been placed with the foster parents since she was 3 months old. At the time of the hearing, she was 2 years and 3 months old. So she had been there for 24 of the first 27 months of her life. In the Navajo Nation case, the child had been placed with the foster parents for 15 of the first 16 months of his life. So again, an even longer time period here. There was significant attachment and bonding based on Dr. Silberman's report and his bonding assessment that was done in December of 2014. He stated these were the only parents that she knows. This is not just an issue about a child who is, say, removed at age 7 and has some normal or regular, ordinary bonding with the foster family, because they treat them well and they like them or whatever. This is a child who has grown up since she was a baby, since any memories that she might have are of these people being her parents, and that has gone on for 2 years. Dr. Silberman stated that it would be very harmful emotionally to remove the child from the foster parent's home. He stated that she would be traumatized and at risk of withdrawal and depression or anger and acting out if she were moved. The Navajo Nation case, paragraphs 30 and 34, talk about removing the child from the only family he had known would have horribly detrimental consequences, according to the expert in that case.
What of the community's argument that DCS failed to find a family member or an ICWA compliant placement?
Okay, this dependency was filed in, I believe it was February of 2013. They did an amended dependency petition in May of 2013, and removing the children from the home, and sent notice to the tribe. The tribe intervened the very next month in June 2013. And the testimony at the hearing was that the case manager at the time, Rachel Hayes, did in fact, I believe in July 2013, contact the tribal representative and had worked relatively closely with that person to try to find an ICWA compliant placement. The tribe did not find anybody until Ms. Alvarez, a paternal cousin, came forward in approximately April 2014, so nearly a year later. The tribe didn't request a home study or placement with Ms. Alvarez until May of 2014, a whole year after the petition had been filed. And in July, the community moved to place DB with Ms. Alvarez. So again, over a year goes by. Meanwhile, mother was refusing to provide DCS with information about father's family or his whereabouts or anything. Father was refusing to comply or to cooperate with DCS and was not responding, was not showing up in hearings, was not providing any placement information. DCS did its parent locate service in an attempt to find the father and other relatives, potential relatives of the child. But, DCS doesn't have access to the tribe's role of members and potential relationships between them. So DCS did everything that it could do under the circumstances to attempt to find relative placements and was unable to find any. The tribe, with its much greater access to information about the families at issue, was similarly unable to find anybody for over a year. So under these circumstances, the trial court found, and I think it properly so, that DCS had made active efforts to avoid the breakup of the Indian family, to find an Indian placement, and had been unable to do so. Just like in the Navajo Nation case, DCS, or at the time I believe CPS, had made efforts in that case as well to find appropriate placements and had been unable to do so. And the tribe had delayed, and again, the court found that it would be inappropriate to order a placement as a sanction for some sort of lack of diligence on the part of the tribe, and that's not what it was about. Just saying that because it took them so long to find a placement, whether through their fault or not, it doesn't really matter. The fact of the matter is that the child had very strongly bonded with the placement, just like in this case, and for an even longer period of time.
Don't you have a set of facts here over and above in the Navajo Nation case that are somewhat compelling, specifically the 3 siblings?
Well, yeah, that was next on my list to get to. Yeah, thank you, Your Honor. Yes, the testimony from Dr. Silberman was that DB was very bonded with her sister, Barbara, at the foster parents' home, that she also had been having a lot of visits with the 2 older siblings, and that they were transitioning the 2 older siblings to the foster parents' home. The foster parents were willing to adopt all 4 of them. The paternal cousin was not willing to adopt all 4, expressed an interest in adopting only 2, DB and the younger sister. And again, based on the idea, although as I believe it was Judge Downey or Judge Roscoe, I can't remember which one of you correctly noted, that she had not been qualified as a Native American child at the time of the hearing. There was suspicion that she had the same father as DB, but nobody had been able to prove that. The purported father had refused paternity testing, and so they didn't know for sure. So the foster parents, though, were willing to adopt all 4. They were willing to have an open adoption, work closely with the tribe and with any Native American relatives to ensure that she will know her Native culture. And the paternal cousin, likewise, Ms. Alvarez, testified that she would be willing to work with the foster parents to help make the child aware of her tribal heritage and culture. So for all those reasons, the court concluded that, like in the Navajo Nation case, there had been enough proof, and when weighing all those factors together, that the current placement was in the child's best interest and that there was, in fact, good cause to deviate from those ICWA preferences. The court very carefully set out the fact that ICWA applied and all the very good reasons for the ICWA preferences in its decision. So this isn't a case where the court ignored the ICWA placement preferences and just did what it wanted to. It carefully considered them and weighed these factors against them, just like in the Navajo Nation case. And so for these reasons, this court should affirm. And my time is just about up, so unless you have any further questions, I'll let that be the end of it.
Thank you.
Thank you.
Rebuttal, Ms. Whitehair?
To distinguish our case with the Navajo Nation case, the Navajo Nation case was thought initially that there was an ICWA compliant placement when they placed the child with a paternal uncle. There, it was determined through the DNA test that that placement actually ended up not being an ICWA compliant placement. Also, in the Navajo Nation case, it was an adoption case where the parents' rights had already been severed. In our case, that's not the situation. The parents' rights are still intact, and her rights have not been severed. Also, our case is a dependency case, and the paternal rights to the mother still exist. And the 2015 BIA guidelines were not available at that time. Now that they are available, the BIA guidelines give us more clarity and a framework to work from, which is in line with the spirit and with the language of ICWA. And to go back to the statement that was made that this was the only parents that the child knew, mother requested a bonding assessment as well, but at that time that was denied, and all the parties stipulated that there was a bond with the mother. Therefore, that was not the only family that Deborah knew. She knew she had a mother, and the courts again as I just said, stipulated that there was a bond with the mother. For the ICWA to mean something, the state must be required to follow its standards. Further, the state must comply with the federal law regardless of whether the tribe intervenes. This case reveals the ongoing problem with the Indian child welfare system in Arizona. It has become the norm for the state to rely entirely on the tribe to locate family placement. If the tribe cannot locate one quickly, the state orders a one-sided bonding assessment to establish good cause to deviate from the ICWA placement preferences.
What in the record for us to consider would require something different other than the statute and the rules as adopted by our Supreme Court?
I'm sorry, if you could repeat that.
The argument is there's a problem with what the state is doing, and I'm trying to discern what in the record was there for the trial, the juvenile court judge to consider in making that assessment that we can consider.
What we're asking you to consider is that the ordinary bonding and the potential exposure to the tribal culture is insufficient to establish good cause. It's not sufficient to establish good cause, and that to establish that it did and it could have would render the rule meaningless. The juvenile court committed reversible error in this case, and the under advisement ruling should be reversed, and Deborah should be placed with her family.
Thank you. Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned. Thank you.